grass not supposed to be green, like faith's not supposed to be seen. The sky's not supposed to touch the ground, and a square's not supposed to be round. The moon's not supposed to touch the sun, and a two is not supposed to be a one. Said the heart's not supposed to weigh a ton, and forever's not supposed to be done. Winter's not supposed to come in June, and I am not supposed to have the blues. There are so many things that are not supposed to be, babe, except you and me. There are so many things that are not supposed to be, ooh, babe, yeah, except you and me. Night's not supposed to be long, yeah. No one is supposed to be alone. Understanding is not supposed to be confused, and the wind is not supposed to lose. Like fire's not supposed to freeze, or like joy is not supposed to grieve. Like you are not supposed to leave what I said I'm not supposed to mean. He is not supposed to have your heart. Baby, we are not supposed to be apart. There are so many things that are not supposed to be said. You and me. There are so many things that are not supposed to be. Hey, baby, it seems just like no seasons changing, or this earth with no creation, or a heart with no feelings, or a sickness without a healing. Just like a frozen spring, or a bird with no wings. Just like a song out of key, that's how my life would be. Like the night skies with no stars, or lonely broken heart. No holding hands or walks in the park. That's how it would be if we were apart. Ooh. There are so many things, yeah, except our love. So many things that are not supposed to be. It's like having nowhere to breathe. No, no. Like having no words to breathe. No, no. Like having no rain for the sea. There are so many things that's not supposed to be. Not supposed to be. Except you and me, baby. Yeah, yeah, baby, yeah. Except you and me.
I stayed into something. So now I'm closer to God. But being closer is hard. The attacks get stronger, become much harder to fight, and they last longer. That's what it's always been. Joy with the pain, dark with the light, sun with the rain. With the right perspective, there can be something to gain.
Yo, can I with you? What?
ACT, do you see this?
Look, if it ain't official DanaJay, Levi for Kelly, or Prima Donna News, I don't even want to see it. Take this off. Look, you got some weed? I gotta get some. All right, hurry up. Diesel and them here, everybody here. We waiting on you. All right.
But I know that there's more. More for you, more for us.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
Say you love me, what you gon' do now? Hope you're ready, cause I'm really about to put it down. Girl, you know that I will never disrespect you. We love tomorrow, but tonight I wanna spank you. That ass count, gotta make it last now. Spread our soul, then I'ma beat it up.
Hold on, y'all. What up, what up, what up, what up? I can't believe I'm really doing this. I really can't. Snap back, Dana. So, hey, okay, here we go. The government has responded. The government has responded. Bro, if you... Hold on for a second, y'all. These people are crazy. Okay. Let's go there. All right. Jesus Christ. Whoo! The crazies are loose. All right. So, y'all know that, the government, we've been waiting on this. The government has responded. And check it. And I'm going to sit here and read it all. I don't care how sleepy I get. Tomorrow morning, I'm going to come back to Miss Bonjean's supplemental. But Miss Bonjean have the final say-so, though. She have the last time to come back at the government or whatever. So, we have less than what we had and before because, when I came last time, it was a lot going on. So, this is where we're going to start. I'm going to go ahead and get everything together. We're going to start there. All right. So, United States of America against Robert Sylvester Kelly, also known as R. Kelly. The government's response to defendant's motion for a new trial pursuant to Rule 33 of the Federal Rules of Criminal Procedure. Breon Peace, United States Attorney, Eastern District of New York. All right. So, table of contents. You got applicable law. You got the defendant was not denied effective assistance of counsel during voir dire. You got relevant background. You got legal standing, deficiency, performance, prejudice, analysis, juror number 3. Formerly prospective juror number 25. Juror number 4, formerly prospective juror number 52. Juror number 5, again, formerly prospective juror number 87. Juror number 7, formerly prospective juror number 145. Juror number 8, formerly prospective juror number 147, juror number 9, formerly prospective, juror number 156, juror number 11, formerly prospective, juror number 153, juror number 12, formerly prospective, juror number 163, alternate juror number 4, formerly prospective, juror number 179. The defendant was not denied conflict-free counsel. Then you got relevant background. Thank you, Charlotte. Hey. Then you got legal standard. Let me see. Move it a little bit. Then you got analysis. Then they got the table of authorities. All these. Ooh, that's a lot. Jesus, dang. Ooh, this is war. Okay, introduction. The defendant seeks a new trial pursuant to Rule 33 of the Federal Rules of Criminal Procedure, Rule number 33. As a result of his conviction on September the 27th, 2021, of 9 counts charging racketeering and multiple violations of the Mann Act, and his motion and supporting memorandum, the defendant argues that he, 1, was denied effective assistance of counsel because his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors. And 2, was denied conflict-free counsel under the Sixth Amendment because one of his attorneys simultaneously represented the victim who testified at trial under the pseudonym Jane. See generally memorandum ECF docket number 270. For the reasons set forth below, the court should deny the motion in its entirety. Number 1, applicable law. Rule 33 provides that the court may grant a defendant's motion for a new trial if the interest of justice so requires. Criminal P33A. However, motions for a new trial are disfavored in this circuit, and the standard for granting such a motion is strict. United States versus Gambino. Accordingly, Courts must exercise their Rule 33 authority sparingly and only in the most extraordinary circumstances. United States versus Sanchez. Got that. The defendant was not denied effective assistance of counsel during voir dire. The defendant asserts that he is entitled to a new trial where his trial team conducted no meaningful voir dire and acquiesced to the seating of jurors who were unqualified to serve on this jury. This claim lacks all merit. Stop. How do the claim lacks merit? If it came out to be truthful and they came out telling things, and then you even had a juror trying to get an autograph, how do it lack merit? The government stopped. They already messing up. See? Relevant background. In order to facilitate jury selection in this case, approximately 575 prospective jurors completed a comprehensive 28-page questionnaire comprised of 108 questions. The court then invited the parties to submit challenges to any prospective jurors based on their questionnaire responses. The parties thereafter submitted a joint list of 251 prospective jurors they agreed should be stricken for cause. In addition to the agreed upon for cause challenges, the government submitted a list of 34 additional prospective jurors, and it challenged for cause for various reasons, and the defendant submitted a list of 145 additional prospective jurors he challenged for cause for various reasons. The court then directed the remaining prospective jurors who were not challenged for cause by either party based on their questionnaires to appear for an in-person voir dire. Over the course of The court then directed the remaining prospective jurors who were not challenged for cause by either party based on their questionnaires to appear for an in-person voir dire. But wait, every juror should have got an in-person voir dire. Okay. Over the course of 2 days, the court conducted in-person voir dire in 2 phases. During the first phase, the court addressed the prospective jurors in a group setting, advising them, thank you, Ms. Lena Miller, advising them of multiple principles of law, including the burden of proof, the defendant's presumption of innocence, and the need to follow the court's instructions. During the second phase, the court spoke with the remaining prospective jurors individually, outside the presence of the other prospective jurors, making further inquiries of each prospective juror, including posing additional follow-up questions submitted by the parties in writing and orally during voir dire. During in-person voir dire, the court excluded approximately 34 prospective jurors for cause for various reasons, including scheduling conflicts, English comprehension issues, financial hardship, and concerns about the prospective jurors' impartiality. After voir dire was complete, the parties exercised their That's supposed to be preemptory? He put peremptory challenges from the pool of qualified prospective jurors, and the court subsequently seated and swore 12 jurors and 5 alternate jurors to hear the case. Following the close of evidence and the court's final instructions, the 12 jurors deliberated, ultimately finding the defendant guilty on all 9 counts in the third superseding indictment. With respect to count 1, which charged the defendant with racketeering, the jury found that all racketeering acts except racketeering acts 3 and 4 had been proven by the government. Stop. How can racketeering acts 3 and 4 been proven by haven't been proven by the government, but they charged him with that when it come to Jane but not with the other one? Make that make sense. None of the alternate jurors was called on to deliberate. I I guess not, because you unsequestered the jurors when it was time to deliberate. B, legal standard. A defendant who attacks his conviction based on claims of ineffective assistance of counsel must show that counsel's performance fell below an objective standard of reasonableness under prevailing professional norms, and affirmatively prove prejudice. They gonna have to start. Jennifer Bonjean gonna have to start naming names down. I.e., demonstrate that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Strickland versus Washington. Okay, well, you can talk about the PI. Accord Hernandez versus United States. Yeah, pretty much. He threw the case. Here we go. That's just case law right there. Case law. Under the Strickland standard, a petitioner must establish both: one, that counsel made errors so serious that defendant was deprived of reasonable, competent representation, and two, that counsel's deficient performance prejudiced the defense. Both prongs must be satisfied to succeed on an ineffective assistance claim, and the court need not address both components if a defendant fails to establish either one, as a failure on either showing is dispositive. Okay, cool. Deficient performance. With respect to the first prong, a defendant must identify the acts or omissions of counsel that are alleged not to have been the result of reasonable professional judgment. The court must then determine whether, in light of all the circumstances, the identified acts or omissions were outside the wide range of professionally competent assistance. Strickland 466. Okay. That's all case law. Let's get out this case law. Golly. That's case law. Griner versus Wells. Oh, so they just trying to put case law in here to prove their point. The Second Circuit has defined a strategic decision as a conscious, reasonable, informed decision made by an attorney with an eye to benefiting his client. Griner versus Wells. Okay, so they can't come back. They just want to cite case law. When examining an ineffective assistance claim in the context of jury selection, consistent with Strickland, an attorney's actions in conducive voir dire are also afforded deference. CPS versus Senikowski. Okay. Indeed, courts are loath to second guess the decisions of counsel during jury selection. Here's another case law. Then here's another case law. Jesus Christ. Okay. Additionally, if a defendant fails to demonstrate that he if a defendant fails to demonstrate that he requested that his attorney exercise a peremptory challenge for particular jurors, the petitioner is deemed to have acquiesced to the attorney's decision not to do so. Okay. It's case law. Dang, they case law all the way through that. Prejudice. With respect to the second prong, an error by counsel, even if professionally unreasonable, does not warrant setting aside the judgment of a criminal proceeding if the error had no effect on the judgment. Lindstadt versus King, which is case law. Thus, to establish prejudice under Strickland, the defendant must show that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different, which it would have. A reasonable probability is a probability sufficient to undermine confidence in the outcome. Well, if the PI would have been on his job and called the folks like he was supposed to, then yes, the case would have been a different outcome. If Sylvia and her crew ain't interfere and get in Canick's ear, and Canick would have been dropping the evidence the way that it was sent to him by various people, then yes, the outcome would have been different. But my opinion, Canick got burnt out at the end because everybody was trying to be the one instead of the group being the one. That's just my opinion. A court must review the prejudicial effect of counsel's errors and the aggregate. See Lynch that. Man, Jesus. Moreover, unlike the determination of trial counsel's performance under the first prong of Strickland, the determination of prejudice may be made with the benefit of hindsight. They talking in circles. To establish prejudice stemming from trial counsel's failure to challenge a prospective juror for cause during voir dire, a defendant must establish actual bias. See Castro versus United States. Oh, Lord, here we go. Case law. However, to maintain a claim of ineffective assistance of counsel based on the failure to object to a biased juror, the petitioner must show that the juror was actually biased against him. And Ms. Bonjean did that. She did that already. She showed how the person was biased against him, how they already said that they watched Surviving R. Kelly and they already believed that he was guilty, and before he even walked in, she showed the bias already. Next, government, what the hell are you talking about? Based on the lack of actual or perceived bias of the jurors, the petitioner has not demonstrated that he was prejudiced by his counsel's failure to strike these jurors and has therefore failed to establish ineffective assistance of counsel. That's a lie. Actual bias is bias in fact. The existence of a state of mind that leads to an inference that the person will not act with entire impartiality. Here's another case law. Actual bias can be found where a prospective juror admits partiality, and the juror did that. Or where the same can be inferred from his or her answers to voir dire questions. Significantly, even where a juror expressively doubts his or her impartiality on voir dire, a finding of actual bias is not automatically mandated. Here's another case law. Holding that ambiguous and contradictory testimony of 3 jurors was insufficient to overcome presumption of correctness owed to trial court's findings that the jurors would be impartial. The test for determining juror bias is well established. How? To hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court. Here's another case law. Even where a juror previously expressed some reservations about his ability to be fair and impartial, if the juror later expresses during voir dire that he will try, keyword, try, that means he will do his best. But what if his best is not to try? What if his best is already made up? Come on now. But Doing voir dire that he will try to decide the case based on the evidence presented, that assurance is genuinely sufficient. No, it's not sufficient. United States versus Town. That's probably in that situation. But trust me, Town was not as big as R. Kelly. Therefore, to prevail on a claim that defense counsel was ineffective and failing to remove or challenge a juror during voir dire, a defendant must show that the juror was actually biased against him, and Ms. Bonjean did that. At 20, without the finding that the juror was actually biased against petitioner, prejudice under Strickland is not presumed. See analysis. The defendant's ineffective assistance claims are wholly without merit. He cannot establish either prong under Strickland or his motion should be denied. The defendant first makes one, generalized assertions that trial counsel failed to conduct any meaningful voir dire of prospective jurors to ensure they were free of bias or prejudice. Memorandum at 11. And 2, unfounded and vague claims that trial counsel should have, for example, probed more deeply. Memorandum 7. Inquired further. Memorandum at 9. Or completely questioned. Memorandum at 12. Certain jurors. These claims are wholly belied by the record, which shows that trial counsel actively participated throughout the voir dire process. No, trial counsel didn't. Because the trial counsel that participated was not the same trial counsel that was on the case. I mean, for that fought the government. Submitting additional questions and assertions challenges for cause, both in writing and orally, in some cases successfully, as to various prospective jurors, including those prospective jurors whose impartiality may have been in question. In addition to the defendant's written for cause challenges, with respect to the approximately 50 prospective jurors initially qualified after the first 2 days of in-person voir dire, the defendant requested that the court make further inquiries of approximately 19 prospective jurors, including additional questions related to the prospective jurors' opinions on the Me Too movement and related topics, as well as their knowledge of the defendant and the nature of the charges. I'm going to say it again. The same counsel that conducted the voir dire was not the same counsel that tried the case. That right there should be grounds for a new trial. Also, the inwaivable rule of thumb, that's also a ground for a new trial. But let's finish. On various occasions, after being certain prospective jurors' responses to the follow-up questions, trial counsel did not challenge them. However, with respect to certain other prospective jurors, for example, prospective juror number 120 and 182, defense counsel challenged, and the court ultimately excused the prospective jurors for cause based on their responses to inquiries related to the Me Too movement. Trial counsel's inquiries on these topics clearly reflect that they considered the very issues now raised by the defendant when making for cause a peremptory challenges, and made strategic decisions in certain instances not to challenge a particular prospective juror based on their responses to inquiries from the court and the parties. That's Guerrero versus Payne, okay, which is another case law. Here's another case law. Jesus Christ. I'm going to skip the case laws. Jurors were made as part of a reasonable trial strategy rather than as a result of counsel's failure to provide effective assistance. Okay, Warwick Maitland. This is all case law. This is case law like a mug. Look at this. All case law. Nor has the defendant shown that he suffered any prejudice. He provides no tangible evidence of actual bias, relying only on speculation based on the challenged jurors' responses during voir dire as purported evidence of bias. Here's another case law. Jesus Christ. Do they have anything that they just, can tell or talk about? They just doing all case law. This is all case. Look at this. All case law. Okay. Let's stop right there. Okay. 3 individuals as to how the jurors were biased. I'm going to go back up and read that. Finding jurors were not actually biased against the petitioner, and therefore he was not prejudiced by trial counsel's failure to challenge them, where petitioner offered no evidence beyond the voir dire testimony of 3 individuals as to how the jurors were biased, other than speculation regarding these jurors' ability to be impartial, given that each of the jurors at issue asserted their impartiality and that they could fairly decide the case. Indeed, the very fact that the defendant asserts that the trial counsel should have uncovered some additional imagined information, but produces no actual information supporting the claimed bias, emphasis to speculative nature of these claims. In addition, the defendant's claims regarding trial counsel failure to challenge prospective jurors who, 1, had some knowledge of the defendant and or the allegations against him, including through affirmative responses to question 31 indicating they had watched or heard interviews of Robert Kelly, TV shows featuring him, or specials or documentaries about him. Memorandum at 4 through 12. Or 2, knew of the Me Too movement. Memorandum at 5 through 8. Also lack merit. How? As the Supreme Court has made clear, qualified jurors need not be totally ignorant of the facts and issues involved. Whoa. In a case. So wait a minute. If Supreme Court made it clear that qualified jurors need not be totally ignorant, right? Then why, when you go to a trial at Supreme Court, if you have any knowledge about anything that's going on in that case or that person, they take you off the jury pool? Make that make sense. Make that make sense. The rest of this is case law. Every case of public interest is almost as a matter of necessity, brought to the attention of all the intelligent people in the vicinity, and scarcely anyone can be found among those best fitting for jurors who has not read or heard of it, and who has not some impression or some opinion in respect to its merits. Here's another case law. Most cases, pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. Internal citation submitted. That's another case law. Rejecting ineffective assistance claim, finding that defense counsel's decision not to challenge a juror was within the realm of sound trial strategy, and that defendant could not establish actual bias where police officer juror advised he could have had personal knowledge of the facts of the case in his employment but did not recall any such knowledge and could remain impartial. Further, the defendant's unsupported assertion that the jurors' own subjective assurances that they could be fair was not sufficient to ensure that they did not harbor beliefs or preconceived ideas about defendant's guilt. Memorandum at 11 flies in the face of both the record and binding legal precedent that it is sufficient if the juror can lay aside his or her impression or opinion and render a verdict based on the evidence presented in court. Diaz, as set forth in further detail below, the defendant has objectively failed to prove that trial counsel did not act strategically in deciding not to challenge certain jurors for cause or use peremptory strikes to prevent their selection. He also fails to show that any of these jurors bore actual bias against the defendant. He therefore cannot show deficient performance or prejudice. Juror number 3, former prospective juror number 25. The defendant asserts that trial counsel was ineffective in failing to challenge juror number 3, given his responses that he had seen a documentary about the defendant and his legal troubles and heard that he has been sleeping with underage girls. Memorandum at 5, as noted above. The mere fact that a juror has knowledge regarding the defendant or aspects of the charges does not automatically create a presumption of bias, particularly where, as here, the juror has indicated that he can set aside his prior knowledge and decide the case based solely on the evidence presented at trial. Bull crap. Bull crap. Bull crap. That's common sense. If a person's seen something and never questions it and goes along with it, when they have a chance to confront that person or be around that person or make a decision on that person, you best to believe the decision is going to be to make sure that person is no longer around. Well, indeed, the defendant completely ignores, as he does with each juror's affirmation of impartiality. Juror number 3's unequivocal statements, both in response to the questionnaire and during in-person voir dire, which reflect a total lack of bias and a clear ability to be impartial. How can you say that, government? For example, in response to question 31, juror number 3 advised that he had seen a documentary about the defendant, but added, "I don't know the full story." Of course, that's the playback you're going to say. Why wouldn't you say that if you want to get on trial and to make sure it's a guilty verdict? Oh, I seen the Harvey Weinstein documentary, but I don't know the whole story. Juror number 1, Mr. DanaJay, Harvey Weinstein, that nigga guilty. He guilty. I seen the documentary. He guilty. So if that can happen like that, then why can't it happen in this case? Oh, because the government says so? And who the hell are you, government? So it says, which reflect a total lack of bias and a clear ability to be impartial. Okay, and then it went to the examples. Don't know the full story. So I have no feelings about it. I remain impartial. How can you not? Time out, yo. Who do you think you playing with? Now, if I can see this, I know Miss Jennifer Bonjean can see this. How? Okay, let's go here. Not how, but yeah, how? How many people worldwide have seen the damning Surviving R. Kelly and didn't run out the house and say, that nigga a monster? Damn near everybody who don't know the truth. So how you going to sit there and say some sugar honey iced tea like that? Man, y'all crazy. Question 31, emphasis added. Moreover, in response to question 32, which asks whether he had an impression of the defendant based on what he had seen or heard, juror number 3 advised that his impression was neutral. Ho! Wait a minute. How can impression be neutral? An impression is how you feel about somebody. You can't have a neutral feeling. It's either you rock with them or you don't. You might not show it. You might show a neutral impression, but deep down inside, you know how the fuck you feel. Make that make sense. You might can be cordial about a case, but you know deep down inside you don't like that person. You know that. Man. Man, oh man, oh man, oh man. My impression was neutral. Adding that the media tends to demonize people. I deal with facts. Wait a minute. You saying you deal with facts. That's what the juror said. I deal with facts. You deal with facts, but your feeling is neutral. That don't make sense. How can your feeling be neutral, but you deal with facts? It's either you love, you like, or you hate, or you dislike. There's no neutral in it. That's like me walking up to the nigga in Bolingbrook saying, yo, what's up? Yo, my feeling's neutral. What? Yo, what's up, man? My feeling's neutral, so what's going on? What? That means this person is badass crazy. That's what that means. Right, Lena? That's like saying people don't see color. So what do you see? Transparency? Oh, no, I see the heart. You're a lie because you can't see the heart. You know that person is either melanin or that person is what they call Caucasian. I've never seen a shade be a color. So let's finish. Juror number 3 also advised that he had not overheard discussion about the case, nor had he discussed the case with anyone or online. Use a goddamn. You know what? This how we tell all this. Why don't y'all release who the jurors were? Once you release who the jurors were, then they can be vetted. And when you properly vet a juror, don't y'all go to the computers? Even if they deleted some stuff, it's still out there in cyberspace. So the truth will always come out. I'm just saying. Don't be a fool, because everybody plays them. Juror number 3 further responded that neither the defendant, celebrity, nor anything about the nature of the case would interfere with his ability to decide the case fairly and impartially in accordance with the court's instructions. Like he gonna tell you the truth, or she gonna tell you the truth. With respect to questions regarding the so-called Me Too movement, juror number, the so-called, golly, wow. They really trying to say the Me Too movement never existed. They trying to say that the Me Too movement was nothing but a fragment of a people's imagination. So I guess Surviving R. Kelly never existed neither. I guess Time's Up and Color of Change never existed neither, huh? Juror number 3 indicated that he was aware that the movement seeks justice for rape victims 25 to 30 years after the fact. That's enough right there. And also stated that he had not participated in the Me Too movement. You don't have to participate to understand the Me Too movement. You don't have to participate to agree with the Me Too movement. What the hell are we asking here? The government is going nuts. And they dancing in circles. Juror number 3 also indicated he had no reason to believe he could not apply the law that the defendant is innocent until proven guilty. And the government bears the burden of proof. See question 65. During in-person voir dire, juror number 3 further affirmed his ability to be fair and impartial. When asked whether there was any reason he could not follow the court's instructions regarding the burden of proof and the fact that the defendant was innocent until proven guilty. That's a lie. If he's innocent until proven guilty, why was he locked up for 2.5 years before he went to trial? That's not innocent until proven guilty. That's guilty until proven innocent. But I also realize that this is legalese, and you really think you can play with somebody who knows legalese. Juror number 3 responded, no reason at all. Ain't that's the one that asked Lawyer Allred for autograph? Oh, but he's not, or she's not involved with Me Too. Whew. When asked by the court whether there was any reason why he would not be able to follow the court's instructions on the law, juror number 3 responded, no, I'm a stickler for the law on my job. I'm the rule guy. What? Moreover, juror number 3 answered that there is no reason at all why he could not follow the court's instruction not to research the facts. Wait a minute, what? Juror number 3 answered that there's no reason at all why he could not follow the court's instructions not to research the facts, law, or people involved in the case. And when asked by the court, is there any reason at all why you wouldn't be able to give both sides a fair trial? Juror number 3, again, unequivocally answered no. In these circumstances, the defendant cannot show deficient performance in counsel's decision not to challenge juror number 3, and also fails to prove any actual bias on juror number 3's part that would result in prejudice failing both Strickland prongs. That's a lie, because everything he just said, it was clear bias. It was just with a cover-up overtone. So you can be biased, but use a different overtone to camouflage it. Come on, federal government, you know better than that. You know better than that. Indeed, it was clearly sound strategy on the part of trial counsel to not exercise a preemptory challenge. Stop. Federal government, how do you know that it was a clearly sound strategy? Y'all wasn't with the defense counsel. Y'all didn't talk to the defense counsel unless somebody on the defense counsel is really working with you all. Things that make you go, Juror number 3 explained in his questionnaire that he had been arrested on 2 occasions, which resulted in charges being dismissed. Question 44. And during the colloquy, with the court emphatically expressed that he had previously had certain negative experiences with law enforcement, and that while he was not biased against law enforcement, he was biased against people in law enforcement that do these things. So if you are biased against people in law enforcement that lock people up for no reason, what makes you think you wouldn't be against a man that the whole world has called a pedophile? Make this make sense. Thus, trial counsel likely made the strategic decision to keep juror number 3 because they believe the juror's past negative experiences with law enforcement, including being falsely arrested twice, coupled with his belief that the media demonizes people. Question 32 would make him more critical of the government's case. Trial counsel may also have reasonably believed that the government might use a preemptory strike on juror number 3, given the government's follow-up questions, which trial counsel may have interpreted as concern regarding juror number 3 on the part of the government in his case law. Rejecting claim of ineffective assistance of counsel, where defense counsel did not object during voir dire process because, among other possibilities, counsel, among other reasons, failed to object so as to force the prosecution to expand an additionally preemptory challenge to strike the juror. Juror number 4, formerly prospective juror number 52. The defendant next claims deficient performance due to trial counsel's failure to challenge jurors number 4 based on the juror's questionnaire that the juror finds transmission of STDs in a non-consensual act to be particularly repulsive. Has a close friend who was a victim of sexual assault and listed the person he least admired as Jeffrey Epstein. Again, the defendant fails to carry his burden to establish either Strickland prong. Juror number 4's questionnaire and voir dire responses in no way amount to actual bias against the defendant. A juror is not required to have entirely neutral feeling. Timeout. A juror is not required to have entirely neutral feelings about the particular types of crimes charged. Wait a minute. If a juror is not required to have entirely neutral feelings, then why in juror number 3 it was said that you have to have neutral feelings, or the juror said he had neutral feelings? That's not making sense. So now what you're saying is that you can have bias against the person when you're a juror and it's okay. No, that's not. They will remove you. Denying post-conviction relief and finding trial counsel's decision not to challenge prospective juror in narcotics trial who expressed views about dangers of drug use given family history of drug abuse was not deficient performance, where juror affirmed ability to be fair and impartial after court advised juror that nobody is asking you to walk in here totally blank. You will bring in your life experiences. What? And that the relevant question was only whether juror could follow the law as I gave it to you, and will you be fair and impartial? Stop. If that's the case, why did you have to change the law in the 9th inning, 2 outs and 1 batter, and the batter stance is 3 balls, 2 strikes, and 3 errors? Make this make sense. And Donnelly had to change the things for them to, okay, you're guilty. How? So ain't none of y'all following the law, Ann Donnelly. Well, you were bringing life experiences, and that the relevant question was only whether the juror could follow the law as I give it to you, and will you be fair and impartial? Rather, the central issue is whether the juror can lay aside any preconceived notions. Here, juror number 4 indicated that he could. We got 25 more pages to go, y'all. Nor was bias established on the ground that juror number 4 knew an individual who was a victim of sexual assault, notwithstanding that the charges against the defendant involved sexual assault. See United States versus Udagwa. Oh, Udagwa. Finding that bias could not be interfered, where juror advised the court that, among other things, his wife had been abused before they were married. In case involving prosecution of defendant for forced labor of 2 young girls, importantly, in response to question number 37, which asks whether there was anything about the nature of the charges in and of themselves that would prevent the juror from deciding the case fairly and impartially in accordance with the court's instructions. Juror number 4 responded no. Question 37, likewise, in response to question 65, which asks if there was any reason why juror number 4 could not apply the law that the government bears the burden of proving the defendant guilty beyond a reasonable doubt or each charge, juror number 4 responded, no, stop. Likewise, let's repeat that. Likewise, in response to question number 5, which asks if there was any reason why juror number 4 could not apply the law that the government bears the burden of proof, that bears the burden of proving the defendant guilty beyond a reasonable doubt. Well, how did y'all prove that he was guilty beyond a reasonable doubt? When Canick poked holes all in the stories. And then he ripped open the story. So how is that? Let's finish. In fact, as was evident from juror number 4's questionnaire and in-person voir dire, juror number 4 had very little knowledge of who the defendant was, confusing the defendant's alias, R. Kelly, with a famous cartoonist from decades earlier. That's a lie. Question 30 and 32. Upon clarification that the defendant was not the cartoonist, juror number 4 had very little knowledge of the defendant and had seen some news articles that did not appear to have made an impression on him. When asked whether there was anything that juror number 4 had read that would affect his ability to be fair and impartial in the case, he responded, not that I know of. He didn't say no. He didn't say nah, not at all. He didn't say please. He said not that I know of. So what if he was sitting, let's hypothetically say this. What if he was sitting in the juror pool and something was said that made him have a flashback, that made him remember and take that not that I know of to, oh, I remember when that happened to me, that nigga guilty if he did it to somebody else. And since they saying he did it to somebody else, guess what? He did it. So not that I know of is a safe way of saying I haven't been provoked by anything as of yet. I'm just saying. Is anybody going to break this shit down the way that I do? Moreover, when the court spoke of the duty of jurors to decide the case based on the evidence at trial, juror number 4 added that the case was to be decided by the evidence, testimony, and your instructions on the law. So, okay, so I'm going to ask this question. If the case was decided by the evidence, the testimony, and instructions of the law, y'all wouldn't have took that long to come back with a verdict. So evidently somebody was conflicted somewhere. So that right there is a lie by itself. Make this make sense. When the court advised juror number 4 that the government bore the burden of proving the defendant guilty beyond a reasonable doubt, juror number 4 responded right and stated that he would have no problem following the court's instructions that the defendant is innocent until proven guilty. How is he innocent until proven guilty? And he was housed in a jail unit. Therefore, any potential concerns that may have arisen from juror number 4's questionnaire responses were alleviated by juror number 4's clear responses by juror number 4's clear responses in the questionnaire. And during voir dire, that he could remain fair and impartial and decide the case according to the court's instructions. In these circumstances, the defendant cannot show either deficient performance or actual bias, and his claim should be rejected. Whew. Juror number 5. And right there, check this out. We're going to take a little 3-minute break. Go get you some juice, something like I'm about to do. And guess what? We'll be back. All right? So I'm going to give you a little something to go get your juice too. Oh! Wait a minute, what in the world just happened? Hold on, y'all. Let me get back to that. What in the world? That's crazy. That's weird. I'm gonna go ahead.
Listen, I don't even want to sing this song. Matter of fact, I'm just gonna talk through this. But I'm gonna talk on notes. But what I'm gonna be saying is the realest. Listen. First, I pop open a can of Red Bull. Then I mix it with some Bell and pour it all over you. Once I get your body tweaking, girl, I drop to my knees and then I'll proceed on this mission to drive you wild. Break out all the candles, oils, and hot towels. I can feel you scratching my back while I'm on top. Damn, girl, said you know the sex is good when you're making those faces. And you know the sex is good when you're going all baby. And you know the sex is good when your body's having fits. Toes curling, screaming out, son of a bitch. Said you know the sex is good when you're coming for the 4th time. Know the sex is good when you can't get it off your mind. And you know the sex is good when you tell your best friend. The room was steaming, I was screaming, son of a bitch. Now 2 hours later, we're still going at it. Girl, from the basement all the way up to the attic. Tease you up until you tell me, girl, I wanna grab it. And that's when I'm gonna bend you over, girl, and let you have it. Said you know the sex is good when
Said you know the sex is good when
you know the sex is good when you're going all, baby. And you know the sex is good when your body's having fits. Toes curling, screaming out, son of a bitch. Said you know the sex is good when you're coming for the fourth time. You know the sex is good when you can't get it off your mind. You know the sex is good when you tell your best friend the room was thin and I was screaming, son of a bitch.
Hey, let's go. Let's go. Juror number 5, formerly prospective juror 87. The defendant claims that trial counsel should have challenged juror number 5 because she had some knowledge of the defendant and had a somewhat negative impression of him. In response to why juror number 5 had this impression, juror number 5 wrote that there was an allegation that related he was sleeping with underage girls, minors. Question 32. Notably, juror number 5 specifically used the word allegation to describe whatever knowledge she may have had about the case. Despite being aware of this allegation, which is no more than was included in the summary of the case provided as part of the juror questionnaire. Juror number 5 advised that she had not overheard any discussion about the case, discuss the case with anyone, or posted any opinions online. See questions 33, 34, and 35. Juror number 5 further responded, that neither the defendant, celebrity, nor anything about the nature of the case would interfere with her ability to decide the case fairly and impartially in accordance with the court's instructions. During the in-person colloquy, the court asked juror number 5 whether, despite having some familiarity with the case, juror number 5 was able to put aside anything that juror number 5 had heard about the case and just judge it on the evidence that you hear in the courtroom. Juror number 5 responded yes. The court asked a second time, stating okay, and put aside all those other things you might have heard, to which juror number 5 again stated yes. Shortly thereafter, the court asked juror number 5 whether there was any reason she could not follow the court's instructions that the defendant was innocent until proven guilty, and that the defendant has the burden of proving the defendant and the government has the burden of proving the defendant guilty beyond a reasonable doubt. Stop. Juror number 5 again responded no. So stop real quick. You think juror number 5, 4, 3, 2, 1, 32, 33 is going to tell you the god daggone truth? In response to the court's inquiry as to whether the court was hesitating a bit in her answer, juror number 5 stated no. There wouldn't be no reason that I wouldn't be able to. Where I work, you have to. Where I work, we have to follow the order. In response to the court's further questions regarding whether juror number 5 would follow this important principle of law regarding the burden of proof and would follow the court's instructions on the law, juror number 5 said yes to both. During this portion of the questioning, juror number 5 initially responded, well, as you mentioned, according to when you listen, whatever you hear, so I think I'll give it a shot. What? Wow. So you cover up what she really said with what you want her to say. But this is a fair and impartial trial. This is fair and impartial juror, huh? Make that make sense. As a result of a colloquy followed in which the court explained to juror number 5 that regardless of her answer, juror number 5 needed to be positive in that response. So now you coaching the juror on how to be with her responses. Seems a little impartial to me. Juror number 5 needed to be positive in the response. When asked if she was positive that she could give both sides a fair trial, juror number 5 said, yes, of course I'll lie. That she could be positive in her belief that she would be fair and impartial. Importantly, juror number 5's use of the word think in her response to the court's questions does not demonstrate implied or actual bias. Wow. Finding no bias when juror replied no. I don't think so. After being asked whether she might favor the prosecution. The prosecution's argument, their evidence, their witnesses, because you are a member of their office. Whoa. And confirmed that she could acquit the defendant if she found the prosecution had not proved its case. What? Finding no bias when juror replied, no, I don't think so. After being asked whether she might favor the prosecution, the prosecution's argument, their evidence, their witnesses, because you are a member of their office. So wait a minute. Why? What? Wait a minute. Why is there a member of the prosecution office on the juror stand? Wait a minute. Why? Why is a member of the prosecution office on the juror stand? That's enough right there. And confirmed that she could acquit the defendant if she found the prosecution had not proved its case. Finding juror had no actual or implied bias warranting relief where when asked whether his experience as a police officer would carry over into petitioner's trial, the juror responded, well, sir, I would certainly like to be able to say that it wouldn't, and I would certainly do my best to see that it did not. But I'm stuck. Why is a member of the prosecution team on the juror stand? Moreover, even if juror number 5's response demonstrated some initial ambiguity about her impartiality, she affirmatively stated that she could be fair and impartial upon further questioning. Trial counsel's decision, therefore, not to challenge her was not deficient. Rejecting claim of ineffective assistance of counsel based on trial counsel's decision not to make a for-cause challenge where juror expressed doubts about his ability to be fair and impartial given his employment as a police officer. There shouldn't have been no police officers on the case. This is crazy. But subsequently answered in the affirmative upon further questioning about whether he could base his decisions in the case solely on what he would see and hear in the courtroom, and where there was no evidence in record that the court would have granted a challenge for cause even if defense counsel objected. Then here come a case law, which I doubt if they would have did that. Holding that the decision not to challenge a juror for cause when the juror expressed that she was sensitive to the issue, but ultimately stated that she would try to remain fair and impartial, did not amount in ineffective assistance of counsel, particularly where, based on the juror's response to a hypothetical question posed on voir dire, the attorney may have reasonably inferred that the juror would be sympathetic to the defense strategy he planned to use at trial. Here's another case law. Finding no actual bias where a juror initially stated that he could try to be fair and impartial and then subsequently agreed that he would leave sympathy and emotions out of his deliberations, and decided from the facts on this witness stand. Concluding that district court did not err in failing to remove prospective juror for cause where juror initially expressed reservations about ability to be impartial about later promise to try to decide the case based on the evidence presented. United States versus Plouffe. Upholding the denial of challenge for cause where a juror indicated he would do his best to decide the case based on the evidence presented, the defendant thus cannot show deficient performance or actual bias and fails both Strickland prongs. I'm just saying. Hey, can I get at least 40 more likes? I got 154 people watching. Can I get 40 more likes? Thank you so much. And Donnelly better not let this go to a Supreme Court. Oh, no. Juror number 7, formerly prospective juror number 145. The defendant asserts that trial counsel was deficient in failing to challenge juror number 7 because she had heard certain information about the defendant's alleged crimes. The claim is baseless. Wow. While juror number 7 advised that she was aware of who the defendant was and the existence of a case against him, juror number 7 stated that she had not seen any documentary about the defendant and that her impression of the defendant was neutral. Here we go with this again. You live in New York. The screening was in New York, and you didn't see Surviving R. Kelly. Man, who you think you playing with? But check this out. Defendant was neutral because most of the information you hear about celebrities are not always true. It's mainly either for or against the person. So if mainly the evidence that you hear is not true, right? Against celebrities, then why was it true against R. Kelly? Make it make sense. Juror number 7 also advised that she had not discussed the case with anyone or posted any opinions about the defendant online. Question 33 to 35. And made clear that she would remain fair and impartial in deciding the case, indicating that there was no reason she could not follow the court's instructions regarding the burden of proof and the fact that defendant is innocent until proven guilty. If that's the case, why was he locked up? If he's innocent until proven guilty, why was he locked up? Can somebody explain that to me? Shout out to everybody that's over here. I thank y'all for being over here. Hey, can I get 38 more likes? That part, Gemini done. We still don't know the jury. During the in-person voir dire, when asked whether she could put aside the very little she had heard about the case and rely only on the evidence in court, juror number 7 answered sure. Moreover, when asked if she promised that she will be a fair and impartial juror to both sides, juror number 7 responded, "Of course. In these circumstances, the defendant cannot show actual bias, and his ineffective assistance claim must fail." Wait a minute, huh? In these circumstances, the defendant cannot show actual bias, and his ineffective assistance claim must fail. In addition, the defendant cannot show that trial counsel's decision not to strike juror number 7 was not strategic. During trial, defense counsel sought to emphasize the defendant's musical talents and popularity as part of its trial strategy. Thus, trial counsel may have believed that juror number 7 knowledge of the defendant's music and her lack of knowledge of the Me Too movement made juror number 7 an attractive juror. In any event, in light of the jurors' unequivocal responses establishing her impartiality, the defendant cannot show actual bias, or the court would have granted a motion to strike. Juror number 8, formerly prospective juror number 147. Jesus Christ. They just going on and on and on and on. They got the same responses going on and on and on. The defendant claims that trial counsel was deficient in failing to challenge juror number 8 because he had heard about the crimes that the defendant allegedly committed. That's enough to take him off right there. Notwithstanding such knowledge, juror number 8 advised that he had a neutral impression of the defendant and that he had no feeling toward the defendant. Okay. Are you sure about that? In response to other questions, juror number 8 made clear that he would judge the facts of the case fairly and impartially in accordance with the court's instructions. During in-person voir dire, juror number 8 answered each of the court's questions in unequivocal manner, consistent with his ability to put aside anything he knew about the case, hold the government to its burden to prove the defendant guilty beyond a reasonable doubt, and judge it fairly and impartially. In these circumstances, the defendant cannot show actual bias, nor can the defendant show that trial counsel did not strike juror number 8 for strategic reasons. In the questionnaire, juror number 8 advised that he listens to the defendant's music and has no views of the cases. But he talked about his cases and his music. So how do you not have views about... Wow. They have yet talked about his 6th Amendment. And I'm 26 pages in. Jesus Christ. Indicating that he had no knowledge of the Me Too movement and could clearly be fair and impartial. Excuse me. Trial counsel likely believed that juror number 8 was a fan of the defendant's music and thus would be a favorable juror for the defense. In any event, in light of the juror's unequivocal responses establishing his impartiality, the defendant cannot show actual bias or that the court would have granted a motion to strike. Number 6, juror number 9, formerly prospective juror number 156. The defendant claims that the trial counsel was deficient and failing to challenge juror number 9 because she had heard that the defendant had unknown issues with the law and had knowledge of the Me Too movement. In response to questions regarding whether juror number 9 was familiar with the defendant or any allegations against him, juror number 9 wrote, "Sounds familiar but unsure," and that the defendant had issues with the law before but couldn't tell you exactly what for. Juror number 9 also indicated that she had a neutral impression of the defendant because I know he's been arrested before but don't know if he was convicted or not. Stop. Why do all these fraud people got neutral positions or take neutral positions, such the government say? That's a lie. I don't watch entertainment news or follow gossip influencer sites about celebrities. In response to a question concerning knowledge about the Me Too movement, juror number 9 described the movement as the power structure of the male-dominated movie industry has been turned on its head, and indicated that she had not participated in the Me Too movement. Stop. If you know that much about it, then I'm quite sure that you participated somewhere down the line. In response to other questions in the questionnaire, juror number 9 made clear that she would judge the facts of the case fairly and impartially in accordance with the court's instructions. During in-person voir dire, the court asked juror number 9 whether she could put aside any prior knowledge that she may have had about the case and decided only on the evidence presented in court. Excuse me. To which juror number 9 responded, "Yes, I can." In response to questions regarding whether juror number 9 promised to follow the court's instructions on the burden of proof, the defendant's presumption of innocence, the law, and refraining from obtaining outside information about the case, juror number 9, as she did in the questionnaire, answered in the affirmative to all, promising to do her duty as a fair and impartial juror. The defendant has offered no evidence to suggest that trial counsel's decision not to strike juror number 9 was anything but strategic. As an individual who had a neutral view of the defendant, did not follow gossip sites about celebrities, and who had a relative who was convicted of a federal crime and served 5 years in prison, trial counsel likely believed that juror number 9 would be a favorable juror for the defense. So you think. In these circumstances, the defendant cannot show actual bias or deficient performance, and his ineffective assistance claim fails. In any event, in light of the jurors' and equal vocal responses establishing her impartiality, the defendant cannot show that the court would have granted a motion to strike. Juror number 11, formerly prospective juror number 153. The defendant claims that trial counsel was deficient in failing to challenge juror number 11 because she had heard and read about the alleged crimes on the news. Specifically, in response to questions regarding whether juror number 11 was familiar with the defendant or any allegations against him, juror number 11 wrote that she saw the case mentioned on the news when the defendant was first being investigated, knew that the defendant is a musician, and that there was allegations of misconduct lodged against him. Juror number 11 also indicated that she had a neutral impression, here we go again, of the defendant because I do not know enough information about the defendant or the case. In response to other questions in questionnaire, juror number 11 made clear that she would judge the facts of the case fairly and impartially and in accordance with the court's instructions. Questions 36 to 39, 65, 93, and 94. Similarity. Doing in-person voir dire. When asked by the court whether she could put aside any prior knowledge that she may have had about the case and decided only on the evidence presented in court, juror number 11 responded yes. In response to questions regarding whether juror number 11 promised to follow the court's instructions on the burden of proof, the defendant's presumption of innocence, the law, and refraining from obtaining outside information about the case. Juror number 11 answered in the affirmative to all, promising to do her duty as a fair and impartial juror. In these circumstances, the defendant cannot show actual bias or deficient performance. Juror number 12, formerly prospective juror number 163. The defendant claims that trial counsel was deficient in failing to challenge juror number 12 because he had heard about the crimes that the defendant allegedly committed from various sources and had knowledge of the Me Too movement. While juror number 12 indicated that his somewhat negative impression of the defendant was a result of an emotional response to the nature of the charges against the defendant. I better not read where this nigga's neutral. After they just said, while juror number 12 indicated that his somewhat negative impression of the defendant was a result of an emotional response to the nature of the charges against the defendant, juror number 12 also advised in that same response that he really never cared one way or the other regarding the defendant. Question 32. In response to other questions in the questionnaire, juror number 12 made clear that he would judge the facts of the case fairly and impartially in accordance with the court's instructions. Stop. How in the hell can he judge it fair and impartially when he clearly said right here that he have a somewhat negative impression? Come on, somewhat negative impression. Man, reading this is making me mad because it's wasting my time. And in that same response that he really never cared one way or the other regarding the defendant. In response to other questions in the questionnaire, juror number 12 made clear that he would judge the facts of the case fairly and impartially in accordance with the court's instructions. Doing in-person voir dire, when the court raised the fact that juror number 12 had indicated on the questionnaire that he had some information about the case, juror number 12 advised the court that it was just minor things in the press. Stop. He should have been released. He should have been released. I don't know why he wasn't released. Nothing I can't recall any specific details. Juror number 12 added that, in fact, the summary and questions included in the questionnaire provided more information about the nature of the case than what he had previously been aware of through any media coverage. When asked whether he could put that information aside and judge the case based on the evidence presented in court, juror number 12 responded, of course. Of course he gonna say that. Stating it most definitely is when the court referenced juror number 12's statement in his questionnaire that trial by media is worse than trial by jury. Facts. So he's pretty much telling you that Robert is already guilty. Why would he say trial by media is worse than trial by jury? Uh-oh. Is he really telling us how he really feel, y'all? Subsequently, in response to questions by the court regarding whether juror number 11 promised to follow the court's instructions on the burden of proof and the defendant's presumption of innocence, juror number 11 responded 100%. Further, with respect to the court's inquiries about whether he could follow the law as the court instructed and refrain from obtaining outside information about the case, juror number 11 answered in the affirmative, promising to do his duty as a fair and impartial juror. The record thus clearly reflects that there was no actual bias on part of juror number 12. Trial counsel's conduct with respect to this juror was also not deficient under Strickland. First, counsel had a strategic reason not to strike this juror. In the questionnaire, juror number 12 advised that he had a friend who was related to Bill Cosby. And as part of his discussion of his opinion on Bill Cosby's sexual assault case, both in the questionnaire and on the voir dire indicated that until the end of the case, I have no opinion. Adding that trial by media is scarier to me than a jury. Question 62. Juror number 12's position regarding Bill Cosby's case not only reflected his ability to keep an open mind unless and until he had all the facts, but also likely formed a basis of trial counsel's strategic decision not to strike juror number 12, given the nature of the Bill Cosby allegation. So can I ask a question? And my question is this: how don't none of us know that the government had looked at the questions and then prompt these people on what to say and how to say it when the time comes? I'm just saying. That's all I'm saying. In addition, juror number 12 had a family member who was sentenced to 10 years in prison. A reasonable attorney could certainly have believed that juror number 12 would be a favorable juror for the defense, notwithstanding his somewhat negative view of the defendant or knowledge of the Me Too movement for this reason. In any event, in light of the jurors' unequivocal responses establishing his impartiality, any for cause challenge would have been futile. Man. Hey, man. Look. 171 in here. Hey, can I get at least 20 more likes? Alternate juror number 4. Here we go. Alternate juror number 4. Formerly prospective juror 179. Finally, the defendant claims that trial counsel was deficient for not challenging alternate juror number 4 as a result of her knowledge that the defendant was married to Aaliyah, and as he characterizes it, for making an untimely challenge to alternate juror number 4 during trial for asking the court's clerk whether the clerk could obtain a photograph from attorney Gloria Allred, who represented certain of the witnesses at the trial on her behalf. Even assuming Argendo, the alternate juror number 4, should have been dismissed, notwithstanding the court's proper determination on the matter, given that this alternate juror did not deliberate and thereby had no impact on the verdict. The defendant cannot show prejudice from her selection as an alternate. Wow. More important, however, appellate cannot demonstrate that he was prejudiced by the trial judge's refusal to excuse the venue person for cause. Since prospective juror was never a member of the jury that convicted the defendant. Moreover, as the defendant concedes, trial counsel did in fact seek alternate jurors number 4 dismissal. As such, the defendant cannot show that trial counsel engaged in deficient performance under Strickland. Finally, as reflected in the record and set forth in great detail in the government response to the defendant's motion for a judgment of acquittal, which is incorporated herein by reference, the evidence against the defendant on all charges was overwhelming, and the defendant has presented no evidence to demonstrate that the juror's verdict was based on anything other than the evidence presented at trial. Wow. Figueroa versus Erico. Here we go. Importantly, while the jury found the defendant guilty on all counts, they found that racketeering acts 3 and 4 of count 1 had not been proven by the government, emphasizing that the jurors carefully reviewed the evidence in the case, honored their oath to find a racketeering act or count proven only if they believed the government had met its burden of proof, and were not clouded by the purported bias, and the defendant now baselessly claims permitted the jury. Wow. Assistance of counsel claimed that the trial counsel's failure to strike juror who was allegedly equivocal as to whether she hold the prosecution to its burden and allegedly evinced a state of mind likely to preclude her from rendering an impartial verdict, lacked merit, finding that in the absence of bias, petitioner cannot satisfy the second prong of Strickland because there is no basis to conclude that had the juror not been seated as a juror, the result of the petitioner trial would have been different. Emphasis in original. According to the defendant's claim that trial counsel provided ineffective assistance of counsel during voir dire should be denied. Wow. The defendant was not denied conflict-free counsel. Oh yeah, we gonna go there. Check this out. Take another break. Stretch a little bit. Because we coming back. And when we come back, we gonna go ahead and try to close it out without no more breaks. All right? So check this out. I'll be back. Go ahead and get something to drink. Go ahead and get something to eat. Stretch out a little bit. Here we go.
Oh!
She's everything to me. There ain't nothing she won't do for me. And every man wants a girl like her. No price compares to what she's worth. She saved my life in so many ways. Cause when darkness comes, she's my break of day. And I know I'm blessed with what I got. Yeah. but still I can't seem to tie that knot. Somebody help me. How do I tell my girl that something came up in the plans has changed? How do I tell my girl that I'm not gonna be able to make it, I'm going away? Tell me how do I tell my girl that I'm sorry, baby, but I just can't? Tell me, how do I look her in her face and have the nerve to say that I'm not ready on our wedding day? Now we have both been together since our roaring high school days. We done walked through all kind of stormy weather, and we have both shared each other's pain. No one could ever come between us two, and I bet my breath that things would never ever change. Now this world of marriage we vowed to, all of a sudden seems so strange. Somebody help me, yeah. How do I tell my girl that something came up in the plans has changed? How do I tell her? How do I tell my girl, yeah, that I'm not gonna be able to make it, I'm going away? How do I tell my girl that I'm sorry, baby, but I just can't? I can't, no. Tell me, how do I look her in her face and have the nerve to say that I'm not ready on our wedding day? My mother know my mother, and it's all good. My brother know her brother. We all grew up in the hood. My cousin's cool with my cousins, and all of our friends, grandma friends. High school, could I let this end when we're supposed to be a family? We can go generations under her and me, yeah. And I never meant to go and waste her time or ruin her life. I got a bad case of butterflies. Somebody help me. Tell me, how do I tell my girl? How do I tell my girl? Something came up in the plans has changed. Something has changed within me. How do I tell my girl? How do? And I'm not gonna be able to make it, going away. How do I tell my girl? How do I tell her that I'm sorry, baby, but I just can't? I just can't, no. Tell me, how do I look her in her face and have the nerve to say that I'm not ready on our wedding day? How do I tell my girl, man, this is the worst, that something came up in the plans has changed? That I ever had to do. How do I tell when I know that she don't deserve it? I'm not gonna be able to make it, I'm going away. So confused. How do I tell my girl that I'm sorry, baby, but I just make a decision right now? Tell me, how do I look her in her face and have the nerve to say that I'm not ready on our wedding day?
Oh my God. I'm looking at job responses. Vi said Alice was juror number 5. Oh God. Let's go. Defendant was not denied conflict-free counsel. Sure about that? Sure about that? Here we go. A relevant background pursuant to his obligations under United States versus Curcio. The government brought certain issues to the attention of the court regarding potential conflicts held by one of the defendant's retained attorneys, Nicole Blank Becker. The potential conflicts raised by the government were set forth in detail in sealed written submissions dated June 14, 2021. The sealed June 14, 2021 letter and June 24, 2021. The sealed June 24, 2021 letter collectively referred to herein as the sealed letters, and incorporated herein the reference. ECF docket entry number 107 and 114. The defendant bases his motion on one of those issues, specifically regarding the possibility that Ms. Becker entered into an attorney-client relationship with certain individuals, including an individual referred to in the sealed letters as Jane Doe number 5, and herein as Jane, sealed June 24, 2021 letter, docket number 114. Another issue also relevant to the instant motion related to the individual identified at trial as Joy or Jocelyn, and is detailed in the sealed letters. Following the government's filing of its Curcio letter, the court appointed independent counsel to advise the defendant on the issues. And on June 17, 2021, the court conducted a Curcio hearing, which was further adjourned to allow the defendant ample time to confer with independent counsel. On July the 15th, 2021, the court continued the Curcio hearing to undermine whether conflicts existed and whether the conflicts were waivable by the defendant. Excuse me. In making its determination, the court relied upon written submissions and exhibits by the government, Ms. Becker and Ms. Gloria Smith Rodriguez, who formerly represented Jane, as well as proffers of information by the government. Ms. Becker and Ms. Gloria Rodriguez, Curcio trial at 4. Based on the information, the court determined that potential or actual conflicts existed with respect to the issues raised by the government, but that all of the raised conflicts, including those related to Jane, could be waived by the defendant. No, the defendant can't waive that. Based on his findings, the court advised the defendant of each of the conflicts and the relevant implications of those conflicts. During the hearing, the court also advised the defendant that he had the right to conflict-free representation, but under the circumstances could waive the conflicts if he so choose. Relevant to the instant motion, the court advised, among other things, that the court also advised the defendant that Ms. Becker could not rely on or share with the defendant or his other attorneys any privileged information she may have obtained from these individuals. Let's go back up for a second. Hold on. Ms. Becker may have developed a relationship of trust with certain individuals, including Jane, and references to the July 15th, 2021 Curcio hearing transcript are cited as Curcio transcript, TR. Jocelyn, even though she were sick, never formally retained as their lawyer, she has confidentiality obligations to them. And given the nature and extent of those communications and the content of them, she would have a conflict if she were to cross-examine either one of them. So that's one of the conflicts. Wow. So pretty much she made it, they made it so that she can't cross-examine Joy, if Joy was to go on the stand, or Ashriel. Cannot rely on or share with defendant or his other attorneys any privileged information she may have obtained from these individuals. Also relevant to the instant motion, the court advised the defendant of the implications of a possible conflict related to an allegation regarding Joycelyn. Set forth in the sealed June 14, 2021 letter at pages 1 through 2, noting that there was not much of a foundation for the allegation. While the court did not make a specific finding as to whether Ms. Blank Becker had committed an ethical violation by contacting Jane while she was represented by Ms. Rodriguez, the court also advised the defendant regarding the implications of such a violation as it related to Ms. Blank Becker's representation of the defendant. The defendant advised that he understood all of the conflicts at 31 through 40. Independent Curcio counsel also advised the court that the defendant confirmed that she had thoroughly explained and discussed with the defendant each of the issues that was the subject of the Curcio hearing. Subsequently, the defendant at the court's request explained his understanding of each of the conflicts on the record, as explained to him by the court and Curcio counsel. At 41 through 47, notably, the court also advised the defendant that he had two lawyers who were not conflicted, Devereaux Canick and Thomas Farinella, but that if he waived the conflicts, the defendant would be given up the right to have Ms. Blank Becker represent the defendant without a conflict of interest. And that's something that he can't waive, and they knew that. And that means that if the defendant were to be convicted at a trial, the defendant couldn't later claim that the defendant's lawyer, Ms. Becker, wasn't an effective lawyer because she had these conflicts or potential conflicts. That's something that you can't waive, though. When asked if he understood both of those implications, the defendant responded, "Yes, I do, Your Honor." Understood means stand under your authority. See how legalese play a factor? Understood in court don't mean what you think it means. It means I stand under your authority. The defendant advised the court that he waived the conflicts and would continue with Ms. Blank Becker as one of his retained lawyers. Yeah, because he ain't had no choice. I mean, if he would have said no, it could. And you got to understand the person's rationale. If he would have said no, it would have came back and bit him in his tail. So, of course, he got to make sure that nothing goes wrong. At the conclusion of the colloquy with the defendant, the court found that it had established that Mr. Kelly is fully competent and capable of making an informed decision, that he has been advised by independent counsel, and that his waiver of those potential conflicts is knowing and intelligent, and so I accept the waiver. Wow. At trial, the defendant was represented by 4 retained attorneys, Mr. Canick, Ms. Blank Becker, Mr. Farinella, and Mr. Calvin Scholar. During trial, Jane testified during the government case in chief, and Mr. Canick conducted the cross-examination of Jane, legal standard. The Sixth Amendment right. So you take 30 pages to get into this. Okay. The Sixth Amendment right to effective counsel generally ensures that an accused may be may be represented by any attorney who will agree to take his case. United States versus Perez. A defendant has a correlative right to representation that is free from conflicts of interest. You got case law there. When a defendant's right to choose the counsel he wants conflicts with the right to an attorney of undivided loyalty, the choice as to which right is to take precedence must genuinely be left to the defendant. Case law. District courts have an independent duty to ensure the criminal defendants receive a trial that is fair and does not contravene the Sixth Amendment. Case law. For that reason, when a district court is sufficiently appraised of even the possibility of a conflict of interest, as the court was here, it has a threshold obligation to investigate the facts and details of the attorney's interest to determine whether the attorney in fact suffers from an actual conflict, a potential conflict, or no genuine conflict at all. Where defense counsel has an actual or potential conflict, the district court must determine whether the conflict is so severe as to require the attorney's disqualification or whether it is a lesser conflict that can be waived in a crucial hearing. Case law. In most cases where a defendant's attorney has a conflict, the defendant may make a knowing and intelligent waiver of his right to a conflict-free lawyer if he desires to continue the representation. What was that? Case law. In only rare cases, an attorney's conflict is unwaivable because it is so serious that no rational defendant would have knowingly and intelligently desired the conflicted attorney's representation. Well, that fits under Rob. They telling themselves right there. Or because the conflict is so severe as to indicate per se that the rendering of effective assistance will be impeded. Case law. Indeed, the Second Circuit has recognized only two categories of such per se violations of the Sixth Amendment that are unwaivable, where the defendant's counsel was unlicensed and when the attorney has engaged in the defendant's crimes. An attorney prior representation of a government witness presents a potential conflict of interest. This is because a lawyer owes an absolute duty of loyalty and confidentiality to both his current and former clients. Case law. Case law. Notwithstanding the limitations presented by this continuing duty of loyalty, a defendant can genuinely waive potential conflicts arising from his attorney's prior representation of a government witness. Case law. The Second Circuit has recognized that our cases support allowing waiver of the conflict that arises when an attorney must cross-examine a former client in order to effectively represent a current client. Case law. Such a waiver is allowed because case law, where an attorney suffers from a waivable potential or actual conflict, the district court must conduct a crucial hearing to determine whether the defendant will knowingly and intelligently waive his right to conflict-free representation. That's case law. Although such a conflict might require a defendant to abandon a particular defense or a line of questioning, he can be advised as to what he must forego. He can then seek the legal advice of independent counsel and make an informed judgment that balances an alteration in the trial strategy against the perceived effect of having to get a new and perhaps less effective defense counsel. The second court has considered a number of different factors in determining whether a conflict can be waived, including, among others, 1. Whether disqualifying the defendant's chosen counsel would create real prejudice to the defendant based on the length of representation and or counsel's familiarity with the case. Case law. Whether there is a possibility that the attorney could be called as a witness at the defendant's trial or implicated in the defendant's alleged crimes. 3. Whether the continued representation would conflict with the attorney's own personal financial or liberty interests, as opposed to the interests of a current or former client. Case law. Case law. Case law. 4. Whether if the conflict concerns that the interests of another client, the attorney's relationship with the other client is continuing or has been terminated. Case law. Case law. 5. Whether any other current or former client affected by the conflict has initiated or joined in the motion to disqualify defendant's chosen counsel. Case law. 6. The availability of measures that might limit the dangers posed by the conflict, such as restricting an attorney's cross-examination for a former client, which also is case law that follows. A defendant challenging his conviction on the ground that he was deprived of his Sixth Amendment right to effective assistance of counsel as the result of a conflict must demonstrate first that the conflict was either unwaivable or that his waiver was not knowing and intelligent. And Rob can prove both. And second, that he was prejudiced by the conflict. Case law. In other words, that but for counsel's unprofessional errors, the results of the proceeding would have been different. Quotation marks omitted. Where a potential conflict exists, courts require that the defendant establish prejudice. Where an actual conflict exists, however, prejudice is presumed, and the defendant is required to show only that a lapse in representation resulted from the conflict, which is case law that follows. A lapse in representation means that some plausible alternative defense strategy or tactic might have been pursued, and that the alternative defense was inherently in conflict with or not undertaken due to the attorney's other loyalties or interests. In evaluating an actual or potential conflict of interest, while actions of any member of a law firm are imputed to every member of the firm, such conflicts are not imputed on independent trial counsel. Case law to come out of that, case law to come out of that. See analysis. The defendant alleges that he was denied effective counsel because Ms. Blank Becker purportedly labored under a disabling conflict of interest that was imputed to the entire defense team. The defendant's argument is meritless. It is based on incorrect claims that this conflict is unwaivable and imputed to the entire defense team, which included 3 other independent counsel from different firms who represented him at trial. During the Curcio hearing, the court determined that Ms. Blank Becker may have developed a relationship of trust with Jane and Joycelyn, resulting in certain possible conflicts, including creating, among other obligations, a duty of loyalty to them. Assuming that Ms. Blank Becker's relationship with Jane amounted to an actual conflict, and the conflict was clearly waivable. Several factors demonstrate that the conflict was waivable, including that 1. The relationship was brief, limited in scope, and terminated prior to Jane's cooperation with the government. The relationship did not implicate Ms. Blank Becker's own personal financial or liberty interests. And 3, the defendant was represented by 3 other unconflicted retained counsel who could, and one of whom in fact did, cross-examine Jane during trial. Case law. The defendant has proffered no facts from which it could be concluded that Ms. Blank Becker's potential conflict amounted to an actual conflict of interest. Nor do any of the cases cited by the defendant support the notion that Ms. Blank Becker's conflict was not waivable. Instead, the defendant incorrectly conflates the issue of whether an actual conflict exists with the question of whether the defendant may waive said conflict. As discussed above, it is well established that an actual conflict is not synonymous with an unwaivable conflict. Case law. Let's see. Conflict was actual. It was also waivable. Case law. Indeed, it is the rare exception where an actual conflict cannot be waived by the defendant, and even if the conflict here was actual, it does not constitute one of those rare instances. Rather, the conflict represents one of the lesser conflicts, such as an attorney representation of 2 or more defendants, or has prior representation of a trial witness that is generally waivable. Case law. Holding that the defendant was entitled to waive a conflict created by his counsel's prior representation of another defendant, despite assertions that counsel was blinded by his own substantial self-interest, and finding that counsel had nothing approaching the sort of fiscal self-interest that was presented in Suarez. Considering that there was no indication that counsel had a continuing relationship with or an exceptionally lucrative retainer from the other defendant. See also Stein, case law. Holding that conflicts arising from trial counsel's prior representation of witnesses were waivable, given defendant's willingness to continue with current counsel despite their being barred from cross-examining counsel's former clients at trial, and the defendant's can't consent to measures that might limit the dangers posed by conflicts, such as a current counsel agreeing not to discuss his former clients with any independent attorneys hired to cross-examine them or conflicted counsel's behalf. Case law. Although counsel's conflict comprised his ability to be a zealous advocate for the defendant, it was nonetheless waivable. We have genuinely found that this type of conflict is waivable. Internal citations admitted. In addition to conflict related to Ms. Blank Becker's conflict arising from any assumed attorney-client relationship with Jane, was not imputed to the defendant's other counsel. The defendant's reliance on States v. Stein in support of its claim to the contrary is misplaced. While Stein held the counsel's conflict was imputed to the other attorneys in counsel's small firm. Independent counsel had no such conflict. Case law. At 329, holding attorney's conflict from prior representation of trial witnesses waivable because, among other things, independent attorneys could be hired to cross-examine those witnesses on conflicted counsel's behalf. Ms. Blank Becker is a solo practitioner, and the defendant's other counsel each have their own business practices. their own independent practices. Thus, Messrs. Canick, Farinella, and Scholar were not members of any firm with Ms. Blank Becker who remained unconflicted. Case law. Finding a conflict was not imputed to co-counsel given that the record did not indicate a genuinely partnership between the attorneys extending beyond the representation of petitioner himself. Given that Mr. Canick, one of the defendant's 3 independent, unconflicted counsel, conducted a vigorous cross-examination of Jane at trial. The defendant has not shown that a lapse in representation resulted from the conflict, even assuming the circumstances presented in an actual conflict. Nor can the defendant demonstrate that he was prejudiced in any way by Ms. Blank Becker's conflict if it was a potential conflict. Hold on. There can also be no question, that the defendant was fully advised of the implications and consequences of the conflict related to Ms. Blank Becker's purported representation of Jane. After being so advised, the defendant knowingly and intentionally waived the conflict and chose to keep Ms. Blank Becker as one of his attorneys. While Ms. Blank Becker's conflict prevented her from cross-examining Jane at trial and from disclosing any privileged information obtained, if any, from Jane to the defendant and the defendants of the counsel, the defendant was advised of those consequences and was well within his constitutional right to choose to continue to retain Ms. Blank Becker. Stop for a second. Why do a corporation keep trying to express constitutional rights? Like I said, first of all, in order for a corporation to do business with a person, with a man, you have to give consent. But see, a lot of people don't know that. Okay. Finally, with respect to the defendant's claim that Ms. Blank Becker suffered from the conflict under fault, the defendant is wrong. Again, the defendant conflates 2 separate issues addressed by the court during the Curcio hearing. As set forth in the June 14, 2021 sealed letter, in an abundance of caution, the government expeditiously alerted the court to speculative information it had received from the defendant's former attorneys related to Joycelyn and Ms. Blank Becker. What? Wait a minute. As set forth in the June 14, 2021 sealed letter, in an abundance of caution, the government expeditiously alerted the court to speculative information it had received from the defendant's former attorneys related to Joycelyn and Ms. Blank Becker. Stop. So the former attorneys of Joycelyn is giving information to the government. But if Nicole had some information that she needed, she couldn't even give it to Canick. That's crazy. That's crazy. Joycelyn did not make any such allegations, nor did the government intend to or ultimately call Joycelyn as a witness at trial. So basically, this whole thing about Joycelyn testifying was a lie. That was just a lie stirred up by Tim Savage just to get a buzz in the media. That's crazy. Everything you said that you wouldn't do, you do anyway, and then expect your daughter to want to come home. Make that make sense. And I mean, Your grown daughter. Let's go there. Your grown daughter. Somebody call the police. Thus, even if there existed the possibility of a conflict under Fulton, no conflict was likely to or did in fact arise. None of the dangers outlined in Fulton therefore existed here. See Fulton 5F3D at 613. Noting that the allegations were by a witness who was testifying against the defendant at trial, making it a different order of magnitude from other conflicts. That means it would have been a more dangerous magnitude. Moreover, in the unlikely event that Joycelyn was to be called as a witness at trial by the government at the time, as set forth in Fulton, the per se, it should have been the pro se, the per se rule advocated by the defendant applies only where the alleged criminal conduct is true, or of the nature that it should be treated as true, not where the allegation is false. Therefore, in order to prevail on this claim, the defendant must show prejudice, given the lack of evidence before the court regarding the alleged conduct. There was no basis to treat the allegations as true. CID at 613. Stating that the considerations relating to the per se unwaivable conflict found in Fulton do not apply to the allegations are clearly false. Thus, if a district court holds a full hearing and can definitively rule out the possibility that the allegations are true, a meaningful waiver is possible, since the falsely accused attorney is conflicted only to the extent that she cannot cross-examine the witness regarding the false allegations. As discussed above, the defendant had 3 other independent retained counsel, including Mr. Cannick, who acted as lead attorney at trial and could have cross-examined Joycelyn if she had been called as a witness, but she wasn't, so how can he cross-examine her? The defendant therefore has not and cannot provide any evidence that an actual conflict existed. They already provided the evidence that a conflict existed. Or that if a potential or actual conflict did exist, that a lapse in representation resulted from, or that he was prejudiced in any way by the conflict. Well, I'm going to say this just for this sake. There was a lapse because when everybody left, Cannick had to get caught up on what was going on. So there's the lapse. Accordingly, this court should deny the defendant's motion in its entirety. Then it says, to the extent of the defendant's reference to misconduct implicating a so-called Fulton conflict, also concerns the potential ethical violation by Ms. Blank Becker for contacting Jane and Joycelyn while they were represented by counsel. Such a violation would not be the type of crime or misconduct sufficiently related to the crimes with which the defendant was charged as contemplated in Fulton. See Fulton 5F3D. Of course, the per se rules does not apply anytime a court learns that an attorney may have committed a crime. The attorney's alleged criminal activity must be sufficiently related to the charged crimes to create a real possibility that the attorney's vigorous defense of his client will be compromised. Conclusion. Based on the foregoing, the defendant's motion for new trial should be denied. Respectfully submitted, Breon Pace, United States Attorney. This is what I got to say about that. Be here 10:30 in the morning. No, 11:30 in the morning. I have Jennifer Bonjean's. I have the joint that she released today. Let's see if it's lengthy or not. Let's see. Okay. We can knock this out. We can definitely knock this out. We can definitely knock that out. So I have Jennifer Bonjean's supplemental motion. And we're going to read that. And we're going to get it in. I thank y'all for joining me. Joyce Johnson said, that's why we shouldn't. Hold on, let me see. Hold on. Joyce Johnson. Let me see if I can find over here. Well, Joyce Johnson said that's why we shouldn't get our hopes up high. That's why we shouldn't get our hopes up too high, because they're going to put some stuff in the game. Of course. But it's nothing wrong with it's nothing wrong with being confident in a lawyer. There's a difference between getting your hopes up high and being confident in a lawyer. There's no need to hope when you have a lawyer that we've seen over and over and over again break the government down. The government got another motion for RSK as acquittal. Oh yeah. Eating pork chops, flame out. Y'all stupid. 18 inches long, stretched out. Wow. Adi Basi. Oh, Jesus. Is this the motion that the government just released? Yes, it is, Grace. Yes, Grace, it is. You do not have permission to use any of this content. Facts, Ann. Don't use none of my content. And that's only for special people. I don't think Dana can read 109 pages a night. You crazy. I can go. Trust me, I can. I can get it in. Tomorrow, con hustle motion. Y'all crazy. Oh, that is tomorrow. At 12 o'clock, ain't it? I'll be on that call. Yo, Ben crazy. Everybody be calling people gay. He's a man. Sometimes you just gotta leave people. He said, "Bobo, Bobo, hey Bobo." But look, I thank y'all for joining me tonight. You know what I'm saying? This motion was running around in circles. Prima Donna in the building. And tomorrow, Dawn the Con conference at 12 p.m. Eastern Standard Time. Okay, good. As long as I know it's Eastern Standard Time, I'm good. Do Bonjean have to answer to the government motion? Oh, you know she's going to. Their whole motion is all about case law and the jury. Facts. They danced around that whole thing, and they skipped that Sixth Amendment. If you notice, they ain't really say nothing about that Sixth Amendment, because they don't really want that to go on. So I want to see what Prima got to say, because I know she got the eyeballs up, but I know Prima ready to go in. And I'm sorry, y'all, but it's the only thing I had to eat tonight. The government. Wait a minute. Judah said, Prima Donna, hey. The government crying to Ann saying, this is not fair. Well, and you know Ann Donnelly came from that office. So I wonder what she gonna say. Jennifer gets the last rebuttal. Oh yeah. Oh yeah. Did you know that a police officer was on the jury? Yep. I read that. Yep. And in fact, it was a police officer but that worked at the same office that Ann Donnelly and that team came from. Make that make sense. Mm-hmm. I knew it. They gonna get this work. I knew it. Man, look. And the stuff Prima been putting out been on fire. Y'all, excuse me. I'm eating wasabi. It's hot. Chinese hot sauce. So, for all the people that's dissing Jennifer Bonjean, like Whitney and all them other folks, I'm gonna sit back and watch this and watch how this play out. Because you know I got jokes too. So y'all better hope y'all Auntie Ann, y'all better hope that she side with her old office. And then, if she is, you better hope that this don't go to the Supreme Court. I'm trying to tell you. Jude over there going off. Had to stay up listening to this. Miss Bonjean about to drop that ether. Oh, yeah. Bonjean didn't come to play. Bonjean walked up in that joint. Bonjean walked up in that joint and just hit y'all with this joint right here. Hold on. Where is that? Jesus Christ, I got so much over here now. I knew you can just go to it. Oh, yeah. Come on, do like that.
Better believe it. If you think I'm here to play around with y'all, goddamn I'm not.
I'm telling you. Vi said, the rest describes the act of using force, coercion, threats, or physical pressure, among other things, to get someone to act against their wishes if a person is acting under duress. Facts. They are not acting of their own free will, and so may be treated accordingly in court proceedings. Facts. Right, at Ann Huff, the Dream Team, Prima Donna, Big Vi, at Ben. They ain't know how many celebrities. It's enough. It's enough. Big Jennifer from now on. Kiki Bowman better come in the mess. Oh, Lord. They say that obviously to discredit R. Kelly, but neglect she got a bigger plan. Facts. Bonjean, that is. Yep. I already knew who you're talking about. Haters click your heels 3 times. There's no place like home. Y'all stupid. Y'all stupid. And Harry Potter Donnelly. They scurrying like rats. Facts. If this go to Supreme Court and Ann ass is grass and Jennifer the lawnmower. Facts. Ann Donnelly, she can be replaced at that point. Professor Dumbledore is going to call Ann Donnelly. Man, look. Leave the slow with the slow. Bonjean about to say, Judge Donnelly, watch me work. Is Levi Letters going to go unnoticed? I doubt it. I don't know. I can't speak on that because I don't know too much about it. I just know what he say. Caramel, Jennifer putting in that work, and they trying to use every crooked trick in the book, but the devil's a lie. Facts. 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 But look, I'm about to get up out of here so I can get up in the morning and read Ann Donnelly part. See, I'm sleepy. Jennifer Bonjean part. Man, y'all be blessed. I'll see y'all in the morning. Peace.
Swimming in you. Hey, little mama said I wanna take her. Dipping your pool. Just go for a little dive, yeah. Hey, yeah, yeah, yeah.
Wow.